All rise. 14A District Court for County of Washington, State of Michigan is now in session. All those having business before the court draw near, the Honorable Judge Simpson presiding.
You may be seated. Court does call the cases of the people versus Emerson Wilson.
Kyle Burdell on behalf of Wilson, filling in for attorney of record.
Your name, sir?
Emerson Antonio Wilson.
All right. What are we doing?
At this time, we are asking that the matter be set for preliminary exam.
Both cases?
Yes, Judge.
To your knowledge, discovery is complete.
Yes, Judge, that's my understanding.
And would people have their witnesses available on the 4th?
We'll do our best, Your Honor.
Preliminary examination in person. March 4th, 2025, 9 a.m. before me.
So, Your Honor, I've been instructed that that date won't work for Mr. Drukas unless it's in front of Judge Perry. So if we could have a different judge or a different date. No. I'll tell him he's gonna have to figure out a make it work.
What do you mean it won't work unless he's in front of Judge Perry? He's picking judges now?
No, he's already in front of Judge Perry, is my understanding.
Okay, and it's 50 feet from the other courtroom. I think he can walk it. Just my thought.
That's just passing on their request, Judge. I'll let him know. Figure it out.
What, that he has to walk down the hallway? All right, well, let me know how that conversation goes. March 4th, 2025, 9 a.m. Those are before me.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Damn segue. Okay, no, I'm not. Not until I get one myself. Court calls the case People versus Richard Thomas.
Kyle Burdell on behalf of Mr. Thomas.
And was it not back with people, Your Honor?
Thomas, please state your name for the judge.
Richard Thomas, sir.
Thank you.
And Your Honor, we are at this time asking for this matter be set for preliminary exam.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 4th.
We'll do our best, Your Honor.
Preliminary examination in person. March 4th, 2025, 9 a.m. You want to pick a judge or what?
No, Judge.
Okay.
For me, I don't care. I'm fine.
Judge Perry.
Thank you.
Bond continued. Just next door. Just next door. I am gonna let it go. Court calls the case People versus Kyle Burmeister.
Good morning, Your Honor. James Fifelski appearing on behalf of Mr. Burmeister, who is approaching. Sir, please state your name for the judge.
Kyle Burmeister.
Your Honor, this is our first PCC. I am asking for a 30-day adjournment. One of the things I need to gather are medical records that I think will be relevant to our defense or potential resolution, and those often take more than a couple of weeks.
Who's medical?
My clients got signed releases that are going out today.
On an unlawful driving away, and I don't,
Well,
not understanding it.
I think they'll be very relevant to the RO charge and medical history that I think will be important to review with the prosecuting attorney.
Any response from the people?
Your Honor, we have one moment.
Sure. Got all the time in the world.
Your Honor, may we briefly approach?
Didn't have that much time, but yeah, come on.
Did I get this today? No, all I saw the paper was this.
Right, okay.
There was only one. It was today.
Your Honor, just to advise the court, when I told him that apparently he missed a court day yesterday, it's not a case I represent him on, but he tells me he has never received a notice. He had a notice for today, and that's why he's here. We've communicated about this case, but he was not aware that there was a hearing. So if the court
Well,
can
that's a bit
rein
odd.
him on
That's
that.
a bit odd
Sir,
because he didn't appear, did a warrant recall, and then didn't appear again.
Nobody, anything about.
You know about another case? Is that a misdemeanor case in this court?
It is.
A misdemeanor case.
Nobody told me when I left on Thursday from the jail that this was the only court date that I've had at all.
He was arraigned, I believe, last Thursday on this case. Is that what you're saying?
Yeah.
You're in the jail. They released him with
And they-
paperwork for this case.
Yes.
So I sounds like it's an innocent mistake. He had no notice of the hearing, but certainly he's here to handle whatever legal matters are in front of this court.
Probable cause conference in the matter that were called upon today will be adjourned to March 13th,
I apologize.
2025, 9 a.m. On this other matter, he got a warrant. He recalled the warrant. The date was set. He didn't appear the first time. Now, granted, there was a snow day, but then he did not appear the second day, and notice was sent out. I recall the case from yesterday because he had the previous warrant, and when I issued this warrant, and he just wasn't here.
To the court's knowledge, was he appeared somehow to recall the warrant, or he communicated with the court?
He communicated with the court to recall the warrant, the first warrant.
Okay.
There was, got dismissed, and that was one other case that I knew about, and I pled guilty to it.
Tell you what, he's going today. He'll get a date, and then he'll appear, and I'll let the magistrate set the bond on it.
Okay, we
At this point,
appreciate
defendants remanded on the
the
warrant.
soonest available hearing that the court can offer. Thank you, Judge.
Court calls the case, People versus Mario Crawford.
Brian Bowling on behalf of Mr. Crawford, Your Honor. Sorry, Ashley.
You here? Are they getting him or Crawford? Court does call the case, People versus Lawrence David.
Good morning, Your Honor. Marie Kim, Assistant Prosecuting Attorney on behalf of the people.
Hey, good morning, Your Honor. Christopher Coyle, P 49708, appearing on behalf of Lawrence David. Mr. David, can you state your name for the record, please?
Lawrence David.
What are we doing?
Judge, today is our first probable cause conference date. My colleague and I just retained in on the case. I believe you signed the substitution of attorney on Tuesday, and the protective order for the Child Advocacy Center video yesterday. We're still waiting on that. I'd like to adjourn the PCC out if we can. I've discussed the 21-day rule with Mr. David, and he's prepared to waive it.
Your Honor, I don't have an objection to the adjournment request. we did get video and everything over to them yesterday, so I'm sure they need some time to review it. I would, however, like to address bond once the court.
All right. Probable cause conference, will the 13th work for you, counsel?
Can we do the 20th? I'm going to be in trial in Oakland on the 13th.
March 20th, 2025, 9 a.m. as to bond.
Your Honor, this is a situation where unfortunately,
No, I wasn't dealing with it, and you guys are walking right in front of counsel.
Mr. Brown.
I know, it was
You
Mr.
have
Brown,
to
so
correct Mr. Brown.
Mr. Brown had no clue. And,
I'm done.
huh? That just created more,
Your Honor.
that you did, that created more reflective light, but don't worry about it. Go ahead, counsel.
Your Honor, this is a situation where unfortunately at arraignment, there must have been some misunderstanding. This is a CSE case that involved penetration of someone who was 5 years old when the penetration started by Mr. David, who's her father. And there have been more than one very concerning situation, and that's the best word I can use at this point. I'm not sure why he was given a PR bond when our office requested $100,000 surety bond in this matter. There are concerns that potentially there may be other victims of this sexual assault. So I would renew our request at this stage of the $100,000 surety bond, and I'd be happy to give Your Honor more details if that's necessary.
Do you have a response, counsel?
Judge, I was not part of the arraignment on the warrant, so I don't know what was stated at the time. I understand that the charges are severe. However, Mr. David does have a tether. He's not a flight risk of any kind. He lives there in the Ann Arbor area. The alleged complainants in this matter live up north with their mother. I have not seen the Child Advocacy Center video yet, so I don't know the weight of what is being alleged at this time. I'm sure the prosecutor does know, and I think the bond was appropriately set at the time by the magistrate.
Well-
Your Honor, maybe I can help a little bit. Your Honor, what the magistrate seems to have indicated, I wasn't there personally, but this is my understanding from the notes, is that he didn't have sufficient information to set the bond that was requested. So again, I'd be happy to give more information, but quite frankly, I think there's been enough to, yes, this is a concern, and it's not just, it's certainly a concern for the victim and potential other victim, and we have not charged that matter yet. However, it's a general concern for the community and minors in the community.
It's my understanding too, Judge, that part of his bond, I'm sure there's a condition of it that he can't have any contact with anyone under 18. So that provision does exist.
That's why. Okay. You're right. I'm sitting there looking at it. Thank you. Counsel, you're aware he posted bond. I don't think there was a PR.
I was told it was a PR bond. Oh yeah, what was the bond posted?
He was given $100,000, and I have I do have the surety in front of me, and my staff let me know that he indeed posted bond.
Okay.
Did the prosecutor, I'm sorry, did the prosecutor indicate it was a PR bond?
That was my understanding.
Yeah, from the notes, that's what she was going for, but I see that the bond was set at $100,000 cash surety and suspended posted.
Yeah, I'm sorry. I was assuming that the court knew that. My video, or not video, the audio goes in and out, so I did not hear the PR portion of it.
All right. So
Possible our office address that Your Honor prior to today, so.
that may be. So March 20th, 2025, 9 a.m. bond will continue as set. Thank you.
Thank you.
Next case, People versus Alton Ford.
Special line for the people.
Your name, sir?
Alton Ford.
All right. You don't have an attorney.
No, I don't know what's going on.
What?
I don't know what's going on.
How did? Was that done? I have the public defender having filed an appearance. But you have, did he retain in?
Good morning, Your Honor.
Good morning. State your appearance. He appeared at arraignment?
Have no appearance and we request.
All right. Counsel, you need to call your appearance.
Yes, Your Honor.
All right. So what are we doing?
Your Honor, we're going to ask for a preliminary exam be set.
Do you have the discovery?
Yes, Your Honor.
I don't.
What?
I don't have it, but he have it.
Your Honor, I'm not sure if Mr. Dox got that from the public defender's office. My most recent notes indicate that there were items sent to the public defender yesterday.
Yes, I did receive discovery from the public defender's office. Yes.
Including 23 videos?
Was that just sent yesterday?
Yes. Folks.
We don't have a copy of his appearance, Your Honor. That's why I'm concerned about whether or not the discovery has gone over.
Recording in progress.
Mr. Ford, do you know anything about any of this? Have you seen the discovery or talked to your attorney regarding preliminary examination?
I'm talking to my attorney and he said he had the discovery and we was just waiting. I don't know. I mean, this I'm just not hearing this from the prosecutor. So
Just now,
now.
just now that there are videos?
Yes.
I'm sorry.
That it's videos. I'm just not hearing that.
Counsel, do you have the videos? I'm not setting a preliminary examination unless all discovery is complete.
Okay, Your Honor. So let's just, I have to check to see if my office has the videos. I didn't haven't reviewed 27 videos. I just asked for a quick adjournment, Your Honor, 2 weeks, if that's good for the court.
Get your appearance in, please. And
yes, Your Honor.
Sir, I'm going to adjourn your proceeding out a couple weeks so you can at least get some clarity as to what's going on. Okay. March 6, 2025, 9 a.m. Bond continued.
Your Honor, put the email address that he sent his appearance to in the chat.
All right, thank you.
And you need to file one with the court. That would be helpful. Court calls the cases of the people. Oh, she up there? Teresa Johnson? She's in two. Okay. Oh, she is.
Good morning, Your Honor. Mary Kay House of the prosecuting attorney on behalf of the people.
For the judge, Portia Feaster, Assistant Public Defender on behalf of Ms. Johnson. Ms. Johnson, please state your name for the record.
Yes, Teresa Johnson.
Thank you.
Your Honor, we would love to enter a plea in this matter. However, Ms. Johnson was not able to sign an advice of rights.
Pardon?
She has not signed an advice of rights. If the court is inclined to do it orally, I think we're prepared to do a plea. I did send in police reports yesterday.
Yes, and I reviewed it. What is the
plea on?
What is she going to do?
Before we let's stay on the record, I want to make sure the court has the 3 sheets of the forms. I believe you filled it out last time. She was going to admit through that happened.
Previously, I'll have to see if they're not listening.
Yeah, they're not loose where they would normally be. I don't know if we retained, well, they were turned in the last time, so.
Yeah.
Was it turned in on all 3 cases?
Yes, Your Honor, and there were 3 separate sheets. There should be one per.
I recall that, but I'm not seeing that.
I can fill out new ones after we enter the plea, if that's.
Fine with me, Your Honor. Whatever, fine with the court.
What's she pleading to? She's pleading no contest, I take it, because
Yes,
I've read 3
no
police reports.
contest. It's going to be in total 3 counts of battery. For some cases, they'll be added, like an added count essentially of A and B. I believe there's 2 of the cases that it's already count 2.
Let's do this. She's in our custody? All right, let me pass it. Get the sheets to me so that I'm real clear as to what exactly we're. And we're gonna check and see if they're somewhere buried in the files before you start.
Your Honor.
So I'm gonna pass, yes, ma'am.
Thank you.
I'm gonna pass your matter, but we're gonna get you called up and hopefully get your case resolved today, okay?
Yes, sir. And then I'll be able to go home.
I don't know that.
Come on, you know that.
What?
You, anyone, if no one else knows, you know. Come on, Your Honor, I've been here almost a
Okay.
year.
You are absolutely right, and maybe I'm just not telling you.
Okay, well, I'll wait on it.
I have at least two.
You have, okay, make sure that, because there may be on one, again. Because on one, it may just not be an added count, so they may not be, I don't know. But
Have
she
to
said
look
there
at
were
them, but
three,
I-
okay. So we'll figure that out. Mr. Feaster? Let me ask you a question. If you had to talk to one of the prosecutors that's sitting in the jury box
I have not.
and you were coming from the back, how would you get there if court was going on?
I would probably wait till afterwards, but if not, I would go around the side, Your Honor, and talk to him over here.
Oh. So you do that so that it wouldn't be interrupted?
Correct, Judge. I wouldn't walk right through the middle.
Yeah.
Yes, Judge.
Okay. Thank you.
Okay.
Court calls case of the people versus, is it Grisha Cheatham?
Good morning, Your Honor. Robert J. Kill on behalf of Grisha Cheatham. Judge, just for the
Ms.
record.
Cheatham, can you state your name? And I'm
Grisha
gonna need a
Cheatham.
camera.
Hold on, let's see. Grisha Cheatham.
Thank you.
Okay. Judge,
We can come for the people, Your Honor.
Judge, just for the record, this is Rita Young's case. She's in trial in circuit court this morning. I have a co-defendant in this matter, so Rita asked me if I would just cover the PCC this morning. I talked to the client and her mother. They're okay with that. And we're trying to set a preliminary exam for both of these young women.
All right.
Your Honor, if I may, a couple of things.
Yes.
Before we set the exam. One is, I have inquired about resolution short of holding an exam for these matters. I've been in talking, and this, I know this is Ms. Young's case, so I'll just address this one today. She sent me a mitigation letter, which was helpful. I then asked her if she's seeking a specific offer for potential resolution. She replied with misdemeanors. It's not specific enough. So at this stage, there has been no offer. I would be open to resolving this case short of an exam, but I would need that communication from Ms. Young. With that said, I believe we are going to have to be a little creative with the dates, Your Honor.
We're gonna have to do what?
Be creative. Means can we set it out maybe 30 days, Judge?
And I'm gonna help Mr. Killowell out here. I think on his matter, part of the concern is his client is in school, which we're all very happy about. I know we all kind of
Yes.
had a part in making
Right.
that happen. So I'm okay with observing it that and making sure she doesn't miss school.
Cool. Okay.
What the difficulty has become is really attorney schedules more than anything, because there are two defense counsel involved and myself. We originally had Mr. Killowald's case for exam on February 25th. That was going to interfere with his client's school, Ms. Steen's school. I believe since then that's changed. However, the 25th of February is no longer a good date. We all agreed that we would like the two defendants, the two sisters, exams to be on the same date. That way, we will only need to take testimony one time as they are co-defendants. So Mr. Killowald, Ms. Young, and myself have been in communication regarding dates. And it seems like we're not able to coordinate the schedules to have the exams anyway. So that is the reason for Mr. Killowald's request.
Very, very, very nicely said. Judge, you being the compassionate and you are, I know you will help defend these young women.
Okay, so you wanted at least 30 days out.
Correct.
Is that the deal? And if I set it for preliminary examination on March 25th, will that work?
That would be great for me.
I apologize, as I told Mr. Killowald this morning, that is not great. That would not work. If we could please set it out a little further, because I don't want to.
So sometime in April.
Yes, please.
Well, April 15th work.
For the future.
Is it possible to go the week before? Just asking. Is it?
No.
No, okay. 15th is fine.
Assuming all discovery is complete.
Yes, Your Honor. Thank you for your consideration, Your Honor.
I feel like I was browbeat, but that's okay. April 15th, 2025, 9 a.m. That's before me.
Thank you, Judge.
Thank you, Your Honor.
And we'll continue.
Yes, yes.
Court does call the case, the people versus Richard Young.
Alen on behalf of the people, Your Honor.
Hannah Mackey on behalf of Mr. Young.
Seeing Zoom.
No, I'm sorry, this is Young. Richard. Yeah, the PE and Young.
Hang on a second. There's two Youngs.
I'm holding, right?
The young isn't. Washington County Jail.
That's who they're bringing. Sure.
Yeah, that's what I thought.
Richard Young, it's the one that we got the last phone call today. Is Richard Young, Zach, the one that we phone call? It was Zach. But we're not setting Zach. Decided
No,
you-
we're trying to find Rashard Young is on setting the beat.
Yeah, but there's no.
Those were shit.
It's one phone call.
Yeah, that's Rashard Young.
No, I think that's Zach. Name for the record.
Rashard Young.
Your Honor, at this time, we would like to set this matter for a PE.
Your Honor, two things. One will be addressing bond what time's appropriate, and then also recently I was reviewing this case, saw on the body cam, we didn't have a different body cam. I requested that today, so we don't have all the discovery. I'm awaiting one more body cam video from a different date that is related to this incident.
If I may, Your Honor, Lauren Brown, Deputy Chief Public Defender, we did speak about that. She expects to have that today, and we think that that'll be plenty of time for us to be prepared for a Plea example. The one works for us. We'll be ready.
It's one body cam.
I believe so, Your Honor.
Okay. There won't be an adjournment of this proceeding if that's not available, but I'll set it. Will people have their witnesses available the 4th?
We'll do our best, Your Honor.
Preliminary examination in person, March 4th, 2025, 9 a.m. before Judge Perry. Continue.
May I?
Oh, maybe not. Go ahead. I'm sorry.
Your Honor, as you probably recall, last week we addressed this defendant's phone privileges. After those were revoked, he then continued to call the victim at a different number that we have under her name as well. He called her, I believe, 23 times. There were some under his own PIN, and then he, after the first day he was in custody, he started using other inmates' PINs to continue to contact the victim in this case. So we have great concerns still that he is still continuing to contact her against court orders.
Your Honor, may we approach?
Yes.
Recording stuff.
All right, record should reflect we had a bench conference in this case. Go ahead. Anything?
Yeah, may I also address, our client has a job interview on the 24th of February and at 11 a.m. And we were wondering if you would able to either give a PR bond or a tether to allow him to go to the job interview.
Well, here's part of the problem with this case, and I'll certainly let the people respond. This case came to my attention for various reasons. There was a hearing, really a hearing, but I heard from the alleged victim in the case. And then upon getting more information, it seems that the parties did not stop contact upon this case and may have even appeared at court together on the date that they were here. Further, the defendant got remanded in part because of phone conversations, then gets remanded this time and still can't follow the court's order. So I'm not going to change his bond. You can certainly after prelim make the argument before Judge Perry, but I'm not changing anything regarding his bond. He'll just remain there, and you know, his phone privileges are revoked, but he's still trying to have contact. So, motion for bond reduction denied. Got to follow the court's orders.
What's our next birthday?
Ms. Collier?
Yes.
Your case by stipulation had been adjourned to March 6th. Yeah, I don't know. And actually MDOC confirmed that with us that it had been adjourned. So I don't know why they still signed you in and didn't inform you that it was the 6th, but.
No, it's, what is the reason for the adjournment?
That I don't have it in front of me. It was signed off on, it was adjourned. Usually that's at the request of defense counsel, but I don't know. And they should have informed you. MDOC should have informed you.
I believe. Yeah, I haven't spoken to my attorney either.
He has a meeting, I believe, later this week.
Okay, I think, have you met, you haven't met with your attorney yet, have you?
No.
Okay, that was, my staff informed me that was the reason for the adjournment. Because they have to get through the process, and supposedly there's a meeting set later this week or later this next week. Later next week for you to meet with them.
Okay.
Okay?
Thank you. Have a good day.
You too. Thank you. Court does call the case of the people versus Dimitri Butler Jr.
Alexander, on behalf of the people, Your Honor.
Mary Rubio on behalf of Mr. Butler, who is approaching. I'm standing in for his attorney of record, David Burgess, with his permission. Sir,
Is that correct, sir?
Yes.
All right.
you state your name.
Dimitri Butler.
Thank you. Again?
Okay, just 1 second.
Come on. Court calls the cases of the people versus Teresa Johnson.
Ready again, Judge. Assistant Public Defender on behalf of Ms. Johnson. Ms. Johnson. Please state your name for the record, Ms. Johnson.
Teresa Johnson.
All right, I now do have the plea forms in front of me. And on the case ending in 5189, court's understanding that the defendant will be pleading no contest to count 2, the assault and battery, and count 3, attempted resisting and obstructing. Upon a successful no contest plea to those charges, count 1 would be dismissed. There's a global agreement that there will be 2 years probation, although I can't bind the court to that, but there will be 2 years probation with assessments and treatment, full restitution on all of the counts, whether they're dismissed or not. That's the court's understanding on that case. On the case ending in 5152, she will be pleading also no contest to count 2, the assault and battery, and count 3, attempted resisting and obstructing, the 1-year offense. Upon her successful plea to that charge, count 1 in that case would be dismissed with the other terms as I previously stated regarding restitution and assessments and treatment. On the 1482 matter, case ending in 0779, the defendant would be pleading no contest also to counts 3 and 4, they're added counts of count 3, attempted resisting and obstructing, a 1-year offense, and assault and battery, the fourth count, assault and battery, The 93-day offense upon her successful plea, counts 1 and 2 in that case would be dismissed. And there is also an agreement, basically the same in that I previously stated regarding the 2 years probation, treatment and assessments and treatment, and full restitution on all counts, even if they're dismissed, including this case. Well, in this case, I guess the agreement is there'll be a restitution hearing that will be set by the court.
That's
Yes,
correct.
Your Honor.
All right. That's the court's full understanding of the agreements.
Thank you very much, Judge. That's correct.
All right. Ms. Johnson,
Yes, sir.
what, you want to raise your right hand to be sworn?
Yes, sir, I do.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. I swear.
All right. State your name again for the record.
Teresa, nominal name Johnson.
All right. Ms. Johnson, it's this court's understanding that you are going to plead no contest to 3 counts of assault and battery, and also 3 counts of attempted resisting and obstructing. Is that your understanding?
Yes, it is. Yes, I do.
All right. Okay. The offense of attempted resisting and obstructing is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes, I do.
The offense of assault and battery is also a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right. 2 things about it I have to make sure that you understand it. First of all, means that you're not desirous or wanting to contest these charges. You understand that?
Yes, I do.
All right.
I do.
The other thing that you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes. Yeah.
And I also have to advise you, because it just works out this way, that although I'm taking your plea, I would not be your sentencing judge in these matters. You understand that?
Yes, sir. I do.
In case the case ending in 5152, you would be sentenced by Judge Valvo in the 15th District Court. In the case ending in 5189, you would be sentenced by Judge Perry in the 15th District Court. And in the other matter, you would be sentenced before Judge Barr. You understand that?
Yes, sir, I do.
All right. Understanding all of that, do you still wish to plead no contest to these charges?
I don't know.
Okay.
I'm not sure. That's a lot.
All right.
That's a lot
Yeah,
to
it
have.
is. Okay. So one of the things I have to do, ma'am, is make sure that you're sure this is what you want to do. So your answer to me telling me you're not sure that that's what you want to do, what I'm going to do is I'm going to adjourn these out 2 weeks, let you speak with your attorney and go through it thoroughly and make sure that this is what you want to do. Okay. I'm not doing that as any punishment to you because of what you said or anything along those lines. I'm just doing that because I want to make sure that you know what you're doing and that you're going to be able to handle what at least is agreed to regarding the sentencing and other things in the case. Okay.
Yes, sir. Okay.
Thank you.
Thank you.
I'll see if we can hold on to these forms.
Thank you.
I will adjourn these matters out to March 6th,
Thank you.
2025, 9 a.m.
Yes, Your
Thank you,
Honor.
Judge.
Thank you.
You're welcome.
Continued. Court calls the case of the people versus Barrage. Ante Scott. 2 cases.
Morning, Your Honor. Raymond Cook for the people.
Chair for Barrage Scott, Barrage Ante Scott.
Barrage Ante Scott, sorry. Thank you. All right, what are we doing?
Your Honor, Mr. Scott would like to, we're here on 2 cases today, and Mr. Scott would like to waive his preliminary exam in both cases and address bond.
Okay. All right. Is that correct, Mr. Scott? You want to waive your right to a preliminary examination in these cases?
Yes, sir.
All right, now you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count in each case.
And as far as bond, if I may address that.
Why don't we do the waiver? Why don't we?
Oh, yeah.
Arraignment, and then we'll address bond.
Okay, thank you. Sorry. Your Honor. Yeah.
You waive formal reading of the complaint
Yes, I waive formal reading of the complaint.
and your client standing mute to the charges.
Yes.
And we waive formal reading, standing mute, both counts, court will enter a not guilty plea. Pre-trial in this matters will be set for
March 6th, 1:30 before Judge Slay.
March 6, 2025, 1:30 before Judge Slay. As to bond.
As to bond, I believe Mr. Ante Scott is being held right now on case 25FB1013. There is a 5,010% bond on that case. My understanding is that this court gave Mr. Ante Scott a personal recognizance bond, a $5,000 personal recognizance bond yesterday in case 2411706. I do believe that the reasons why a personal recognizance bond would have been justified then count for this case as well. Mr. Scott is not a flight risk. He lives in the community. He is willing to follow any kind of conditions the court sees appropriate in order to be released. He would just like to.
No, he's not.
He would just like to return.
He's going to give, I will say this. Don't look at me like that, Mr. Scott. We've been through this before. He's going to give his best effort. He really is. He's going to try his hardest. And then it just happens. Go ahead, counsel. I didn't mean to interrupt you, but I just had to, because I know Mr. Scott told you that.
Well, on Mr. Scott's behalf, it is just this one case that is holding him, and it does appear he has personal recognizance bonds in all other matters that he has. So I would ask, just because Mr. Scott would like to be able to kind of, family, attend to his health matters, and work out in the community while he is handling these cases. He would request, and I would request.
He got to go see now. Which family member?
My grandma, my granddad.
Okay,
and just my sister and stuff, the people that was helping me out in the past years, that my auntie. And I won't. I'm just gonna do the right thing. Just bear with me one time.
One time.
I mean,
how many times have you been here? Can't even count that high, can we?
No, sir.
No, we can't.
But I will do what you tell me to do. Just please.
Anything else, counsel?
I would just like to, reiterate that I understand that a matter was before this court yesterday, and it seems like a personal recognizance bond was appropriate at that time.
Only because I knew he was going to be held on this one. But go ahead.
Well, I'd ask the court to consider this bond motion in light of the argument presented.
Response from the people.
Your Honor, I leave it to the court's discretion.
Just tossed it right in my lap. Okay. What is my case that I have him on? Do you remember what charge was? What was your charge on the case you had before me yesterday?
Just a paraphernalia gave me personal bond, and you told me conditional yesterday, and I thought I was leaving yesterday, but that's
I know.
And Your Honor, I would add that Mr. Ante Scott is willing to go on tether in this court if that is.
We tried that too.
If
the only thing the tether did for us is we saw where you got in trouble.
I won't get in no more trouble. I won't. Yes, ma'am.
Sometimes I have no idea what I'm doing. I'm gonna grant your motion for a bond reduction. I'm gonna give you a PR. Barrage,
Yes, sir.
understand something.
Yes, sir.
You still have the case before me.
Mhm.
Okay?
Yes, sir.
So if you mess up, you know what I'm gonna do.
Yes, sir.
And then I don't want to hear any whining and pleading.
Yes, sir.
Here's the other thing I'm gonna do. I'm gonna call Judge Slay
Okay.
and I'm gonna let her know what I did.
Okay.
And if you mess up, you're gonna have both of us to deal with.
Yes, sir.
And I don't think anybody wants to deal with that.
No, no, sir.
All right.
So can I ask one question?
Oh, boy.
Mr. Scott, I would advise you.
No, you can go ahead and ask a question.
No, no,
because
I
I
was
may
just-
change my mind. Go ahead. What's your question?
No,
bro?
I was just gonna ask you, I can't remember. It's okay.
You couldn't remember?
I can't remember.
It left you, didn't it?
Yeah.
Yeah, that's probably a good thing.
That's all I want to say.
That barrage, that's angels just stepping in, stopping you from doing something stupid. All right, thank you.
Thank you, Your Honor.
He'll be back in a week. What?
We all, we're.
We're rooting? Oh, okay, we're rooting.
No, it's the radio silence.
Yeah, no, everybody over there is not. Everybody from the prosecutor's office. We have faith. Yeah. All right. Nothing from the defense side. All right. Court calls the cases of the people versus Forbes Dabney.
Morning, already cooking people.
He's in jail.
Good morning, Your Honor. Hannah Mackey on behalf of Dabney.
Dabney, can you state your name, please?
What's going on here? Hello? Hey,
Hello. Okay.
what's going on?
Tell the judge your name.
Oh,
You
Sam.
recognize that as being Mr. Dabney, because I don't know that we're gonna
Yes, Your Honor.
get an
Hello,
entire.
where am I? Hello, who?
Okay.
All right,
It's
I'm seeing a little better today. And I'm hearing just as well, I guess. I'm impaired. So this is, who is this am I with? Hello, can you hear me out there?
Yes, I can hear you, Mr. Dabney. This is Judge Simpson, okay?
Oh, Judge Simpson, okay.
All right, so Mr. Dabney, here's what I'm gonna do. Okay, your attorney has asked for a forensic evaluation. I'm gonna sign that order and give you a new date to come back, okay?
What does that mean? It sounds like.
Okay,
you
that
said-
means there are gonna be some folks that are gonna talk to you, and they're just gonna tell us how well you are and whether or not this matter can proceed forward.
What are you trying to say? Am I stuck here in this jail again?
Well, I don't know what's gonna happen with you in that regard, but I'm just telling you what we're doing today, okay?
So I'm not leaving today. Is that what you're trying to tell me?
I'm telling you, you're not leaving today, but what will happen is your attorneys will come down and talk to you about that, okay?
I
So,
think that's unusual. The behaviors of the judge should not be had a right to do that. I don't think. Some people are holding me against my will.
Okay. Okay, well,
This all
they
some
they
kind of
may
way.
they may come back to me and then we'll figure out something, okay? On that. So I'm gonna order a competency hearing on a forensic evaluation and
What is that word
competency
you
hearing.
said? I
Hold
can't hear
on,
it.
hold
I
on.
hear it.
Hold
Say
on,
it
Mr.
again.
Dabney. I'm gonna set that for May 22nd, 2025 at 9. Okay, and I'll continue, at this time, I'll continue your bond on that case. Now, I've got a new case.
What is a bond?
Hold on a second.
What's the bond stuff all about?
What's the bond?
Yeah, that's kind of stuff I don't know Why you gotta
Okay,
do
you can
what
talk to
you're
your
doing?
attorney about it, but right
All right.
now on that case I just did, what do you have? I don't have a sheet in front.
Where's my attorney?
Hang on, I'm gonna answer your question. Let me just find the paper. Pardon? Okay, your bond is set at 10,000 in that case.
Why? I don't believe.
Okay, well,
right.
here's what you do. You talk to your attorneys about that, and if they want to raise that before me, they can bring a motion to the court, okay?
Well, there's something wrong here.
Okay, so, hold on, Mr.
Judge,
Dabney, now we got,
You telling me that you got something against me?
no, I don't have anything against you, Mr. Dabney.
Well, why are you holding me here then?
Well, I'm not gonna change the bond until I get something that tells me I should.
Well, what's this bond crap about? I want to know something about it. And my attorneys are not talking to me.
Okay.
I don't even know I have an attorney.
Mr. Dabney, this is Ronald Brown. I came to see you.
Attorney.
Ronald Brown, appearing on behalf of Mr. Dabney. I came to see you yesterday for about half an hour, 45 minutes.
Where are you now? I don't see nothing but a piece of paper here. Wait a minute.
You asked for my name and I gave you my name. I can make a bond
Okay.
argument if you like, Your Honor. He's 70 years old.
Where is he? I want to see him on the screen here.
I'm at the podium. I'm right here in an
It's
orange
not
tie.
switching off of me. Can you do a podium view?
Where is he?
Hang on.
I want to see him. I haven't seen him but once. Where, or help me. Who's this?
It's your attorney.
Oh, that's him?
Yeah, you saw me yesterday and I wrote my name down on a piece of paper, Ronald Brown, remember?
Is that you? I see you now, yeah. But you don't.
Yeah,
look
we
like
talked
the
about
person I
these
saw
things yesterday, correct? And you told me that you have medical conditions, that you have high blood pressure, that you have a heart condition, that you have vision challenges as well as hearing challenges. We talked about these things yesterday. You told me that you were an airplane pilot and that you also that you have a number of patents that you're working on and that you would like to continue working on those patents. You told me about your girlfriend. You told me about you taking tea and herbal medications instead of those medications that were prescribed for you. You told me that you had a heart monitor inserted underneath your chest by St. Joe's Hospital within the last several weeks, that heart monitor is irritating you, and you asked me to implore or urge the judge to allow you to get released so that you can get your proper medical attention through your medical, for your medical needs. We didn't talk about these things yesterday?
Yes, we
Hello?
did. So what
Okay.
you're trying to tell me is now you're gonna talk later on?
I'm talking to the judge now to give him reasons to think about releasing you. That's what I'm doing right now. I said I would do it.
Thank you. Then continue on. I think we're getting positive. We're getting.
So you're
somewhere.
happy with my performance?
You're doing good, guy. I like you a lot. Yes.
Thank you.
Let's move on. Now, first,
So
one
I'm-
more thing I want to say to the judge. If
Tell him.
that's my way I could say something, the way I like to say, that the procedures that are going now against me with all these things is beyond my understanding to be a living soul on the face of the earth subject to the UCC codes of this thing. So I don't like what's going on with this court. And that's why I'm adjusting all these things, because I'm a living soul and a national, and you guys have gone beyond the power of the territory of the people of Michigan. And
Okay.
I don't like
Thank you for that. And Mr. Dabney, I'll think about that, and Mr. Brown will certainly bring all of those issues before the court. Now, Mr. Dabney, there's another case that I have for you that is charging with resisting and obstructing a police officer.
I object to that.
Okay. And
You know,
I
and
haven't.
there are reasons
hold
why
on.
that is.
Hold
He
on,
did not-
hold on, Mr. Dabney, hold on. You haven't been arraigned on it. But do you want Mr. Brown to represent you on that, the public defender?
Yeah.
Okay, so
That's
this is
what we
public
need to
defender
do.
case.
Is that what
He's
this
not been arraigned.
process-
You wait formal reading, he stands
Is
mute.
that what
Yes,
this
Your Honor.
process all about right now?
Well, that's part of the process.
Okay, then go on. What else is it?
Okay, well, hold on. Mr. Brown will be down to explain all of that to you.
All right. And I have some other questions I want to ask before you go with
So
him.
let me finish this part, okay?
Go ahead.
So on this case, there's also been a request for a forensic evaluation. I will set this matter for, rather than a PCC, we'll just go to a comp hearing. We'll set that for, what was her name?
March.
No, who
May
said that?
22nd?
Yes.
May
Who said
22nd. I'm gonna set a date. Hold on. May 22nd, 2025, 9 a.m. All right?
But who said that though?
Who said
Was
what?
it you, Brown? Was it you, Mr. Brown?
The judge sets the dates.
Oh, the judge said that? It wasn't Brown
Yes.
who said that.
The judge said that. He set the date for you, Mr. Dabney.
Okay. So I'm gonna set your bond in this case as just a $1,000 bond, okay? Not the 10,000. Mr. Brown will argue your bond at some point before me, okay?
Something don't
I'll
sound
come-
right here.
I'll come down to see you and you'll give me additional information so that I can make more arguments why you should get out.
All other standard conditions, including no assaultive behavior or possession of any weapons. I will also no alcohol, recreational marijuana, or any other. All right, Mr. Dabney, thank you.
You're not gonna answer my questions, Tim? You're not gonna answer my question.
I answered all of your questions, sir.
Well, what was my answer to my question that I asked you?
What was your question?
Where's my things that has to do with taking this, finishing all these things with monies? Instead of fiat money systems, where's my bond? Not my bond.
Okay.
My minor
So
estate.
what you're gonna have to do,
I want to talk to my
you're
attorney
gonna-
about my minor estate.
this is what I want you to do. Mr. Dabney, I'll hear you and give you an answer to the question. You talk to your attorney, Mr. Brown, and he'll get all of that information to me.
Okay,
And then
then,
I'll make a decision.
as a judge or as a people?
As the judge, yes, that's what I do.
The judge
Okay.
with,
All right. Thank you, sir. We'll be in touch. Court calls the case. Thank you, sir. Court calls the case. People versus Justin Tittle.
Morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
Well, well, well. No, I'm just saying. You just stayed over here in the corner now. I didn't know if they were going to give you anything to do.
They let me play a little bit.
Oh, okay, all right.
Hannah Mackey on behalf of Mr. Tittle, who is appearing to my right. Please state your name for the record.
Justin Tittle. Thank you, sir. All right, what are we doing? An adjournment on this for discovery?
Yes, Your Honor.
I'll adjourn this then to March 6th, 2025, 9 a.m. Bond will continue.
May I address Bond real quick?
Sure.
Your Honor, Mr. Tittle was in Wayne Court on the 6th, and the judge there did grant a motion to
He
reduce
was where?
Wayne County.
Okay, all right.
And the judge did grant a motion to reduce his bond to a PR bond with tether, as long as he gets sent to the Salvation Army for treatment. However, he was remanded back to this court or back to this jail just for this matter, and we are asking that you follow that.
Does he have a bed available?
He does have a bed available, Your Honor.
Okay, have you talked to inmate services regarding that? I don't have a problem with his release to treatment.
May we approach with the order?
Yes, Everybody wants to talk to me, close and personal, come on. To reflect, we had a bench conference and it was quite productive, even though some didn't want it. That what's gonna happen is, sir, they're gonna talk to jail services, try to get all that coordinated. I have no problem. I'm gonna deny the motion at this point, continue your bond. Once I get that order, I'll sign it, and then hopefully everything will move forward.
Okay.
Okay?
Thank you.
All right, thank you.
Your Honor.
She didn't even know what you think. All right. Court calls case People versus Taylor Walden.
And is that we got people, Your Honor?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Walden. Mr. Walden, will you please state your name for the record?
Taylor Walden.
Thank you.
Your Honor, we are asking that this matter be set for a preliminary exam.
All right. And all discovery is complete.
Yes, Your Honor.
And people would expect to have their witnesses available the 4th.
We'll do our best.
Preliminary examination in person will be set March 4th, 2025, 9 a.m. before Judge Perry. As to bond.
Your Honor, it has come to my attention that this defendant has been making phone calls from jail to third parties, and in these calls, he's saying things like, "You should probably have her come down here and drop these charges," referring to the victim. "She needs to go down there and do that. 50 grand, I think, out of here, time to make sure she goes to court or goes down to the courthouse to get the charges dropped." He says, "All right, just have her go down to the courthouse." Among other things, I just have concerns that he's contacting third parties to have them contact the victim to get her to not participate.
Response.
Your Honor, I can't speak to the jail calls. I haven't had a chance to review them. I will say I met with Mr. Walden yesterday. I discussed the no contact order. I advised him not to be making any jail calls. It has come to my attention that the complaining witness in this case is present today, and I believe spoke with the victim advocate. I'm not going to make any requests regarding any contact or anything of that nature, as he's held currently in custody, but that's as far as I'll speak to regarding the jail calls.
All right. Well, I would normally hear from a victim in a case regarding if she wanted something changed, he or she wanted something changed. I'm not going to, given the information that I've heard at this point, because I don't know if those communications which she'd be giving to me are now tainted by whatever these jail calls are. And so Ms. Apple will allow you to listen to them, and if they want to raise it before Judge Perry, certainly can. But at this time, there's not supposed to be, part of your bond conditions are that there's not supposed to be contact, direct or indirect, with the victim in the case. You have to follow court orders, and your failure to follow the court order in this case, pending a hearing on it, I'm going to revoke his phone privileges so that he won't be making any calls.
Understood.
Thank you. Court does call the case of the People versus Amy Ruth Walden.
Good morning, Victoria Burton here, Assistant Prosecutor. People.
Assistant Public Defender Chelsea Virgils with and on behalf of Amy Bullens, who appears via Zoom. Ms. Bullens, unmute and state your name.
Amy Ruth Bullens.
Miss, and let's see, I have before me a plea form that indicates that she'll be pleading. It doesn't say how, but I'm assuming guilty.
Yes, Your Honor, she would like to accept the offer to plead guilty to improper possession of a firearm with the agreement to be sentenced under prosecutor's deferred.
All right. I don't see where there would be an objection to that, but I can't bind the sentencing judge on the matter to that, but all right. So my understanding is she's going to plead to count 2. Is this the maximum penalty of 90, 100? Is that correct?
I believe so.
All right. Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Amy Ruth Bollins.
All right. Ma'am, you can put your hand down. It's this court's understanding that you are going to be pleading guilty to the charge of improper possession of a firearm in a motor vehicle. You understand that?
I do, Your Honor.
That is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that?
Yes.
All right. And understanding that, you still wish to plead?
Yes, Your Honor.
All right. And to that charge, how do you plead?
Guilty.
All right. Ma'am, I do have to also advise you of one other thing, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that, ma'am?
Yes, Your Honor.
And you still wish to plead guilty?
Yes, Your Honor.
All right. You understand that by pleading guilty, you will not have a trial of any kind?
That's correct, Your Honor.
All right. Because of that, you'll be giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, ma'am?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Yes. Tom Eberts told me that there would be off the record. I apologize. That was wrong information. I recant that. Judge.
Okay. So let me ask you this, because I just have to make sure the record's clear. Has anybody promised you anything that has not been stated here today to get you to plead to this charge?
No, Your Honor.
All right. Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and because you believe that you're guilty of this offense, ma'am?
Yes, Your Honor.
All right. On September 3rd, 2012, the location of 1500 East Medical Drive, City of Ann Arbor, Washtenaw County, State of Michigan. Were you in a motor vehicle?
I had a motor vehicle.
Okay, were you in a car at that point, at some point on that day?
Yes, Your Honor.
Okay. And in that vehicle, did you have a firearm?
I did, to protect myself.
Okay. When you had it in the vehicle, you would agree that you didn't have any lawful authority to carry that vehicle to carry that weapon in that fashion?
I had no idea.
Okay, you had no idea of what, ma'am?
Okay. The reason why I had that firearm is because I just lost my husband in a
Miss
horrific
Bullins? Sorry, Miss Bullins, you don't have to go into the reason why. Remember we talked about what you could say, you know, what happened, about how you had this and you knew you weren't supposed to. Do you remember we talked about that?
Yes.
Is that true? You had the firearm in your vehicle and you knew that you weren't supposed to?
Yes, Your Honor.
Okay. And just so that we're clear, you didn't have any lawful authority to carry that weapon in that fashion, did you, ma'am?
No, Your Honor.
All right, very good. Counsel, have I complied with the court? Well, would it be proper to accept this defendant's plea?
Defense is satisfied.
Doing good.
Court will accept the defendant's plea to count 2. The count 1 will be dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be March 14th, 2025. What time? 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor. Miss Bullens, I'll give you a call.
Thank you, ma'am.
Thank you, Your Honor.
Wait, come on.
He's busy.
No, he's I don't know. No, he was over there meditating or something. I don't know what he was doing. No, I didn't mean to wake you. My bad for disturbing you. I'm sorry, man. I just didn't feel safe. Okay, I'm sorry. I didn't mean to. Actually, it wasn't me trying to call you out. No, Allie was trying to get your attention because she saw her coming up. She's like and you weren't paying any attention. So everybody was trying to help you. No, not at all, right? In fact, I'm just going to guess. I don't know your mom, but I'm just going to guess she's probably told you not to do it.
Yeah.
So you don't listen to her, and you're not listening to me or the court. You just want to play by your own rules, don't you?
No, sir. No, I don't.
Because otherwise you wouldn't have done it last night. Young man, how old are you?
18 now.
When was your birthday?
December 21st, 2006. It's my birthday.
So we turned 18 this, as I told the court, it was charged originally in a juvenile matter and then it was dismissed and they recharged as adult.
You understand, young man, that you are facing a life offense.
Yes, sir. Yes, Your Honor.
You understand that?
Yes, Your Honor. And it's taken a lot for me to realize what position I am in, and
I don't think you get it. You found yourself in a position where maximum penalty is life or any term of years. Have you graduated high school?
no, sir.
No, you haven't even graduated high school and you're facing a life offense. And then somebody just gives you some simple rules to follow, some simple things not to do. And you can't do that. You can't follow your mother's rules. You can't follow the court's rules. You can't follow any rules. So you tell me why, if you're just going to throw away your life, why I shouldn't just lock you up right now?
No.
You tell me why.
Improving, sir. And
Improving how? You're smoking last night. Tell me how that's an improvement.
I do it. I'm gonna tell you why. I usually need to study or focus study, and it helps me focus while studying. I listen to music, and I honestly no harm for it, and
you will never do it.
I would never do it again. I can quit it whenever I'm not addicted to it or anything. I just like it because it helped me study. I got good. My grades are improved now. Back since I've been out. I've been having.
Did you tell your mother you needed something to help you study?
I said I prefer. I asked.
Did you tell your mother that?
No. No, sir.
Because you're just so grown, you took it on your own.
Sorry. I was trying to do things on my own, and clearly I messed up, and this just shows that I need my mother to supervise me and to.
You're not listening to her. I don't, and I'll be honest with you, I went through the bond form, Mr. McGoes. I don't understand how he has a PR bond. I don't.
So the family would not be able to make a high cash bond or a significant money bond. He came to the court with no prior history of any misconduct. He is high school senior, on track to graduate. I explained to the magistrate how the family has all come together to take care of this, help assist this young man through this time. He's on a tether, on house arrest. All he is able to do is go to school and church. And I believe those are the two places that he's gone to.
Yeah, those are two places that I've only been.
He is not a risk of committing any offenses, not a risk of.
Yes, he is.
Any.
Because he did it already.
It's possible, and not to excuse anything here, Judge, but it's possible that I didn't explain the conditions sufficiently to this young man.
How's that feel with your sword in your chest?
I don't think I understand the court.
I don't mind attorneys falling on the sword for their client,
Thank
but
you.
this young man is not listening. He is not. He is just going to decide to do things his way. And I think his problem is he's running to the wrong judge to try to do stuff his own way.
Understood, Judge. I would suggest that perhaps if he were to test regularly and prove to Your Honor that he does respect the court, does understand what he needs to do.
You know, Mr. McGolis, I don't mean to interrupt you.
No worries.
It's almost not so much about respecting the court, although I do require that. But you know, I'm sitting up there watching on the Zoom screen and I see his mom just standing beside her child. And it's the fact that you don't respect her that is really irritating me. And because of that, you're not even doing the things to respect yourself. You're an 18-year-old kid up here facing life for what? And again, I don't know your mom, but you got these charges come up, you got your mom scared to death.
If Your Honor would like to speak with her, she'd be more than happy to talk to the court. Right?
I'll tell you what, I'll hear from mom on
Your Honor, and I probably mentioned this already, but he's in his last semester. My concern is that if he's detained for long.
Oh, I know.
Yeah, I know Your Honor knows.
I know.
I just wanted to put that out there. And
you know what? If I don't care about his education, about his life, what if he doesn't care, why should I?
I think he does care. I think he's just made some mistakes. And
He's not listening.
He's never talked to you before.
Oh, I can tell.
Meaning he's listening to you, Judge.
Mom, is there anything you want to say? I know this is not. Excuse me one moment.
Please.
Let me see where he wants her to speak.
Put him over there with you, Alen, and then mom can come up so I can hear her. Mom, you can come on out. State your name.
Nicole Barrow.
All right. What do you want?
What
do you want to tell me?
I know most moms will say that they have like a good kid and they give you this long spiel and then they do something bad and they're like, oh no, you should believe it. But when I tell you, like, I'm in shock, utter shock. He was really a good kid and still is. I did not know. I knew he had a vape, but it wasn't marijuana. And I did tell him it was bad for his lungs. Prior to that, he was my only child that I knew for sure was going somewhere. He's never smoked, never been in any trouble. Him and his brother had started a business where they were selling hoodies in school. He would even be the one, helping me around the house. He's got a brother 16 months apart from him. I moved up to Ann Arbor 8 years ago so that he could go to a baccalaureate school because my two oldest children went to Cass Tech. His older brother went to Eastern and somebody laced his weed and sent him on a trip. By the grace of God, he came back. He's got a degree now. He's going to U of M this fall for software engineering. He even got a STEM scholarship. So that was the example that I was showing my younger children. Don't smoke weed. Don't hang out with these kids. Started hanging with some new kids that were older than him in college. And then I think turning 18, he thought he could,
just
be rebellious and grown. Yeah, and not knowing. I just ask that the court show mercy. And I know this isn't something light or to be taken lightly, the charges that he's facing. We don't consider it lightly. We come from a good background. Our family, civil rights activists. I don't know if you ever heard of Willie Barrow, my aunt.
Yes.
Joe Lewis, my great uncle. I'm doing well at Blue Cross. I'm making a name for myself with the CEO. I'm back in school.
Ma'am,
So he comes from a good family. I'm sorry.
I do not doubt that at all.
Yeah. So this is hard.
I do not doubt that you as a mom have tried to do everything within your power to give him the tools and everything else so he could succeed. That is not a doubt. Like I said, I don't know you, but when I saw you on the screen, it wouldn't be easy for you, but if you just walked away from your kid that might have done wrong, I don't know that anybody would blame you necessarily. You didn't do that. You were standing cheek to cheek with him. So understand any decision that I make, it's no reflection on you.
Sure. I understand.
But what I also understand is I've been doing this long enough to realize if he keeps getting away with this stuff, he's either going to end up in prison or in a casket. Don't shake your head because you have no idea. You think you know too much, but I'm going to show you about what you do know. Mom, is there anything else you want to tell me?
He thought marijuana was legal and he could do that. And then they didn't tell us that the probation. I know it's wrong, but they didn't give us restrictions or say anything to him. And I think he didn't know it because that's what he said coming in. If that, I know it's not helpful.
I got you.
I thank you.
His bond
allowing
conditions are what his bond conditions are. I understand they may not have told him, but you told him.
Yeah,
He knew.
I did tell him. And I just asked if you do make a bond, can you make it affordable for me? It's just me. And then I've been missing work already. I've missed almost a month. They're on me. I got to go meet with my HR on Monday about my job. This is so hard. And I told him I was only messing up at work because of this. I thought I could handle it.
Okay.
I'm sorry.
No, do not apologize.
I'm so sorry.
What time's your appointment on Monday?
In the morning when I go to work at 8 a.m. I work in Medicare Advantage, the Blue Cross. It'll be 2 years in May.
What time do you get out of work?
4:30.
All right. Okay. You work, how far is it from your work to here?
It takes me about 45 minutes.
To get here?
Yeah.
All right. Okay. Thank you.
Thank you.
Anything else from either side before I do what I'm going to do?
Your Honor, the people's original request was for $25,000. That was before the people were aware of the new violation with the marijuana. This time, people will be requesting refunded for the violation. I know the court indicated that I'd gone through the bond request form. I know my colleague did a fantastic job outlining all the facts. I did just want to again emphasize the severe injuries and assault that occurred on one of the victims here with the broken nose, chipped tooth. She was bitten in her hand as she was trying to fight the defendant for control of the car keys. I think remand is appropriate at this time.
I have nothing additional to add, Judge. This isn't the time to talk about the facts. We do have compelling defense to this case, but I'm not going to get into them now. This is a first offense, first charge of the lifetime for this young man. The family does not have money to pay a high bond. I would, if Your Honor was going to change the bond, I would suggest something in the range of 10 to 25,000, 10% if possible.
But if I make it higher than that, then family doesn't have it. And then he doesn't graduate.
Correct.
And everything's a mess.
Correct.
Man, anything you want to say?
Hold on. I just want to say that I do learn from my mistakes. I'm getting closer to God. I know I do look at my mistakes and I know it impacts my family and I know it impacts my mother and it really breaks my heart. I've been improving. I've been improving in school, my business. I'm helping opening up a business today actually for pregnant women for a pregnancy pillow. Like I'm trying to like do the right thing and I won't smoke again. That's no problem for me to not smoke again. I won't like. Other than that, like I've been following my probation rules. I've been texting my probation officer. Have not committed any other violations. I've been going to school on time, and I really apologize to the court. I'm sorry. I apologize to you. And that's it.
There's something. So I'm sitting there listening to your mother, and then understand something. You will never, ever possess the right to break her heart. You just don't have that right. Normally, an easy thing for me to do is to accede to the people's request. If I accede to the people's request, you're not out. You don't graduate. Everything becomes a whole mess. But it also seems that if I let you out, you can't seem to follow the rules or do anything. So what I'm going to do is I'm going to think about it. And I'm going to decide what I want to do. But you're not leaving here today, Mr. Allen. What I'm going to do is I'm going to revoke your bond. You sit there and you think about it. I'm going to set a bond hearing 4 o'clock on Monday, 4 p.m. I'm setting 4 p.m. so you can get into the building. Ma'am, you get to work. You get here. We'll be here. We'll wait for you. Okay? We'll finally have somebody that's waiting on you as opposed to you waiting on everybody else and everything falling through. But what you're going to do, young man, since you can't seem to understand what kind of life you're kind of headed to, you ever been in jail?
Yeah.
For how long?
They put me in here for 4 days.
On this case, Judge.
Well, you're going to be back in. And then when come Monday, you might just stay in. You have nobody to blame for this but you. So at this time, defendant is remanded. We'll see you on Monday. You ready, Mr. Fleischer?
As I'm gonna be judged.
Court does call the case, People versus Jeremy Walter.
Ashley Lonnie for the people.
Torshell Fleischer, Assistant Public Defender. On behalf of Jeremy Walter, to the podium, please.
Jeremy Walter.
Thank you, Judge. Thank you for giving Walter the opportunity to go to community corrections and to have his another sample given and tested. We did receive the results that sample was positive. I followed up and asked for the levels from the February 18th date to today, the 2/20 date, and those levels do appear to have gone up.
Skyrocket would probably be a word.
Well, yes, Judge, that would be accurate.
Okay.
My client, I spoke to him about the skin and asked him if there was anything he wanted to tell the court to clarify things. He's still adamant that he did not use any marijuana intentionally, and I informed him what was likely to happen, Your Honor.
May I respond?
You may.
Thank you. What's of particular concern to the people in this case is that really the 218 test, the test on Tuesday, is our first test.
Correct.
The defendant was placed on bond, I want to say the middle of January, but I'll have it pulled up here in just a moment. And at the time that he initially went on 117, he said he didn't have the money. 127 he missed, 24 he missed, 214 he refuses. 218 we finally get a test and it's positive, and today 220 the test is increasingly positive. The reason that I'm particularly concerned in this case
is because there are underlying mental health issues at play. The people do believe that we're at least in part responsible for the things that led to the charges. In my professional experience, the combination of THC with mental health challenges can be really disruptive. And it's difficult. I am very concerned about the defendant and his behavior while on bond. And I will leave any decision about the bond violation to the court's discretion.
Only thing I can say to his credit, Judge, that he did go test when we ordered him to. He come back. He did not flee, run. He's not sure how it's got in the system. He did have some housing insecurity. When he thought there might be some using at that location, he left that housing location to make sure he was not around any narcotics. He's not sure how this could have occurred, but he's obviously very apologetic that it's positive, and he understands the court's how the court treats these situations generally. I've made that very clear to him, but he says that he has not been using to his knowledge, Your Honor.
I'm not even sure what to say. I mean, as I'm looking at this, it's clear that first of all, we had a series where he's not testing. Then he's unable to test. Then he tests, it comes back positive. Then we're not necessarily dealing with it at that time. And then I get him here and he's got an opportunity to tell me something's going on. And he's telling me it's all he's not sure, or some mistake on his part. And then I get the levels and it's clear it's not a mistake.
Like I said, to Mr. Feaster here, that I was, because of my bond stipulations and the no contact order with my parents, which is where I was living before, I was living in a place that I realized was not safe, and I about 36 hours ago moved out of there because I realized that people were using there, and so I moved. I put everything in my car and I moved to my to a place where I can be safe and be private and not be around people using. So I made a significant effort to remove myself from a situation that I realized was dangerous. So I am making significant efforts. It was not easy to move, to put all my belongings in my car, and to have faith that it was going to work out for me to stay in an office of the nonprofit that I volunteer at. But I made that significant change in order to remove myself from a potentially hazardous situation. I'd just like to say that.
Only thing I'll add, Judge, is that my client was trying to retain counsel in this case. He's met with two different attorneys. I think he's planning to have one for his next court date. I'd ask the court for the soonest possible adjournment the court is able to give him so that he can hopefully see you again and have new counsel present for that next court date.
Probable cause conference will be adjourned to February 27th. I'll set it to next week, 2025. 9 a.m. or as his invite indicates. At this time, given the positive test, I don't believe that the defendant is telling me the truth at all, that he's intentionally violating the conditions of his bond. So for those reasons, I'm going to revoke the defendant's bond. The defendant is remanded.
Thank you very much, John.